is a no on agreement, so.
There's just some issues with some of them, Judge. I couldn't just say yes and they go in, and I understand they changed it again this morning, so I'm catching up just a minute to see what changes they made. I think they removed some, I believe.
Yes, we didn't add anything this morning. We whittled it down based on objections just to speed things up. So there's not additions, there's
But
subtractions.
I'm ready to discuss.
Well, Mr. Whitney, are you driving the ship on exhibits this morning? Or is Mr. Anderson?
I'll try, and if he needs to step in. So the first is 2011-001 to 007. Then we skip 6 pages, and it's pages 14 to 41. These are the records of Dr. Hinchke. We've removed those 6 pages because I think they were subpoenaed in a letter. So those are gone. And then we have an objection here of redaction issues.
Right. So, Judge, there are 2 issues. Yeah, if someone could put
Well,
it.
I just had to turn the system on. It was
Okay,
for
I
not
could
turning the
hand it to
system
the
on.
court if that's easier, since they don't want this. It's sort of a sensitive issue, Judge. Can we
Do you want to
approach?
just hand me the
Yeah, can I
documents
hand it
without
to you?
putting them up?
Yeah. It's on several pages, but it's the same. So I'm handing you 3025-0030. The orange is what they would like removed, and the green highlighting is what we would like removed. No, what you already removed.
You said 3025. We're on 2011.
I thought you were on Henschke records.
We are.
Isn't that Henschke?
Perhaps it's the same thing.
It's the same.
I think it's
the same
a
information.
defense exhibit, plaintiff's exhibit versus defense exhibit, yeah. Same record.
Why is it?
Well, you're right. It's the same. I get it.
Why is
So
it
is
a
it-
different number?
Because we designated and you designated.
Oh,
Marked for
okay.
elimination. Does it go to 41? Yeah. Okay.
Both designating
Sorry.
it, now they're, maybe, if both designated, maybe it just should come in. Okay, what's the
Again.
issue?
The orange highlighting is what they would like removed, Judge. We are sensitive to the issue. The problem we have is when we had our meet and confer on this issue, I asked Mr. Anderson what type of claims are going to be being made, and one of the ones he expressed was that Maya is going to have difficulty in the future with a husband and with a regular life. And so I thought, well, I can't agree that this comes out until I know what types of damages they're claiming. Otherwise, we're sensitive to it and have no issue with it.
Okay, how about the green?
Except I would say, Judge, we're amenable to the details. If I could just give the specifics, I guess. The green, we believe needs to come out, Judge, because there is no claim. This is having to do with the new claim that they wanted to make. There is no claim. We believe it would be prejudicial for that to come to the jury because it would indicate that the I didn't show it. That there is such a claim when in fact there is no claim being made for that. And so that it's highly prejudicial to the defense if that comes in without it being relevant to any of the claims pled or being litigated in front of this jury.
The statement, as Johns Hopkins has stated many times, is not specific to Johns Hopkins. And so their position has been there's a prior interaction of this nature, so we don't think it should come out.
That statement is clearly intended to imply Johns Hopkins,
Okay.
Judge.
Well, the green has to come out where it starts with unwanted touching under the guise of an examination through did not say anything. With respect to the orange, let me hear any argument on that one. Do you need to see this again?
Yes, sir.
So to be clear, we don't have an objection
No objection
for
to that coming
this
out.
sentence, the one that starts with sometimes, and then pregnancies, we don't have an objection to that line, that's clearly doesn't come in. It's this part,
Yeah, that's you want that in.
Depending on what claims are being made, sir. I mean, if there's not a claim being made about her future,
No,
that,
shots, Mr. Anderson.
Sure.
yes. And if we remove it and put it back in, if they open the door,
Judge, this is completely irrelevant.
The question is, are you making a claim along the lines that Ms. Crowells was just saying? If the answer is yes,
What's the specific? It depends on how far, let me just say this for the record. We do not claim to have anything that would amount to a loss of consortium physically in any of our claims for damages for her. We will have testimony that she'll have a difficult time with all relationships, including her partners, her friends, her family, her employees, and that will have an effect on her life. But we are not making a claim that she's going to have less of an ability to have consortium with her husband, like that.
Well,
so that's not part of our...
if you're going to make the claim as you assert, then it is relevant.
How? Judge, I don't understand what the... And if it is, I don't understand why 403 wouldn't take this right out. Because the probative value of this is as to what? She has a boyfriend and she's, lost her... she's active. That, if we are not talking about a loss of ability in that area, it is not relevant to her ability to have friendships or her ability to stay married or anything else. Because we're not saying that she's not going to be able to have relationships that way. So, and so why bring it into this case and hurt this girl? It's embarrassing. She does not want the world to know this. And it certainly, unless it is so desperately necessary for their case to prove or disprove something, I do not see the benefit of hurting her.
Judge, I present the implications. They choose what claims to bring and not bring.
I've already said that if Mr. Anderson is pursuing the claim along the lines he's saying, it is relevant and should come in.
I do agree the second line that starts with,
Yes.
that starts with sometimes and ends with,
Yeah.
that can come out. I mean, that's a very specific detail that doesn't need to be in the record. Can I show the court?
I remember, that's fine.
Okay.
But the other portion of the orange, if the claim is as Mr. Anderson is saying it is, then the other part of the orange should be able to come in.
I'm fine with everything other than the right here.
Sometimes.
Yeah.
Well,
No,
the
that
sentence
is-
was sometimes Ms. Crowell says she's not seeking
this-
to put in and can be redacted.
We agree this line does not need to come in.
Well, without waiving any objection to it, that would be better.
Well, that, agreed. I'm not trying to do
Yeah.
anything harmful here, sir. I'm just trying to respond to your claims
you
you're
know,
making.
If my choice is that if it's going in, I would prefer it not to go in with that language.
And I think Ms. Crowell is saying she's okay with that language not coming in.
So we're in agreement
So
on that.
Yes, sir.
She only
Starts with
gets
the
the...
word sometimes.
Okay, now, who is going to be redacting this document